Priya madam will start the class, will start the webinar.
Yes, madam. Piyush, shall we start?
Yes, we can start. So, shall I start with the presentation?
Good morning.
Okay.
Let me
Only
start.
2 minutes will take.
Yeah.
Okay.
Good morning, one and all.
Good morning, ma'am.
I welcome you all for today's program, which is organized by our college on IPR awareness. First of all, I would like to welcome our today's guest, Piyush Lende sir. He is Assistant Controller of Patent and Design. Also, I would like to welcome our principal, Dr. Poonam Nathani madam, as she is continuously providing numerous opportunities to our students by motivating to organize such fruitful webinars which help our students to enhance their knowledge in various fields. I would like to welcome all my colleagues, friends, students for this webinar. As we all know, in this emerging era of technology, role of intellectual property is very important. We all must aware about it for the coping all problems with which we can handle it easily. Due to lack of knowledge of IPR, we can face many problems. In fact, Piyush sir, I would like to tell you that this is the main subject of our academic curriculum also. Now, I would like to invite our principal, Dr. Poonam Nathani madam, to brief today's session. Thank you. Over to you, madam.
Thank you, Priya madam. Respected our today's resource person, Dr. Piyush sir, all my dear colleagues and beloved students. Actually, it gives me immense pleasure to extend the words of welcome to our today's resource person, Dr. Piyush Lende sir. Sir, on behalf of Dayanand Education Society, Dayanand College of Law, I am here to extend the words of welcome to you, and we are really very happy to receive you at this virtual platform, sir. Even I want to appreciate and want to express the gratitude to CGRC department for providing the experts for conducting this IPR lectures. Last time also we conducted, Dr. P. Shri Sudha madam was invited. She delivered the lecture, and today Dr. Piyush sir is there with us to guide us, to enlighten us on the most significant topic. Actually, intellectual property rights, intellectual property, it is a significant tool in today's era where intangible properties are secured, where our rights are secured, and where the innovation is promoted and protected, and which is having the enormous contribution in our nation's economy and self development also. So sir, on behalf of college, I welcome you, and we are very glad to receive you at this platform, and hope that we will be having very fruitful session. Over to you, Priya madam. Thank you.
Thank you so much, madam, for giving brief of today's session. Now, every program is incomplete without introduction of guests. I would like to invite Dr. Mamta Parikh, madam, to give introduction of our today's guest.
Thank you, Priya madam. Very good morning, everyone. I, Professor Dr. Mamta Parikh, take this opportunity on behalf of Dayanand College of Law. I feel privileged to introduce today's esteemed, eminent, learned speaker, Mr. Piyush Lende sir. Sir is a graduate in Electronics and Communication from Visvesvaraya National Institute of Technology in Nagpur. He pursued his Masters of Technology in Embedded System from prestigious institution BITS, that is Birla Institution of Technology and Science from Pilani. Sir has a vast experience as the examiner of patent and design at Patent Office Chennai and Mumbai. Presently, sir is holding a post as an Assistant Controller of Patent and Design at Patent Office Mumbai. The final decision whether the applicant to be granted patent or allowed register the design resides with the controller. So we are very extremely happy to have you here, sir. Thank you.
Thank you so much, madam, for giving such a nice brief introduction of our today's guest. Now, I would like to request Mr. Piyush Lende sir to take charge of the webinar. Over to you, sir.
Thank you, all the students, and thank you, ma'am, for giving me opportunity to deliver this lecture on intellectual property rights. and this is a very important uh, intellectual properties are very important for the development of the nation, and today's world is uh, developing on the basis of intellectual property, and it is having much uh, focus by developed nation and developing nations today nowadays in intellectual property. So I will give the brief introduction to all the important intellectual properties. So let's start with the seminar, and we will go through the slides and we will discuss the points on intellectual property.
काय हा माझ्याकडे म्हणून जातो
सर आपका
I
माइक
request
म्यूट है सर.
students to mute themselves. पियुष सर तुमचा माईक म्यूट आहे आणि बाकीच्यांनी आपापले माईक बंद करायचे आहेत.
Okay, am I audible now?
Yes sir.
Okay, sorry. So intellectual property refers to creation of minds such as inventions, design for industrial articles, literary, artistic works, symbols, which are ultimately used in commerce. This is very important to know here that intellectual property comes from the mind, and it does not require any kind of resources. It like our normal tangible property like land or vehicles or any things that you keep with you, and all those tangible property. Intellectual property is a different kind of property, and we'll go through how to register this property and how to protect such things. The most important thing that intellectual property rights allow creators or owners to have benefit from their works when these are exploited commercially. This is very important to know that intellectual property are not just to take a rights, but it should be exploited commercially. It should give commercial advantage to the creator of this intellectual property. In that perspective, intellectual property law are designed. These rights are statutory rights governed in accordance with the provision of corresponding legislation. The statutory rights, you are the all the law students are there. Those statutory means it's governed by the law. Whatever the applications for registering the intellectual property we receive, our office receive, we go through a statute that is given by our constitution, and we follow that statute. We follow that act and supportive rules. So whatever intellectual property generally people requires to register, they have and we have and everybody have to follow those laws. And as we know that law is same for every person and law is not biased, and it has a territorial extension of all over the country. The same thing is also true with intellectual property and or intellectual property law, that all over India it is same, and any person can register their intellectual property with following the rules and acts. So we will go through what are different types of intellectual properties are there. So there are different forms of intellectual property. Few most important forms are patents, design, trademarks, copyright, geographical indications, plant variety, protection of undisclosed information, trade secret, layout, design of integrated circuits. We'll go through in detail with each and every forms of intellectual property. Let's come to the first and most important intellectual property, that is patent. Patent is a statutory right. I already told you that it is governed by the law, the Patent Act and patent rules. It is a statutory rights for an invention granted for a limited period of time. Patent is a intellectual property right that is granted for the invention. Generally, everybody knows what we mean by invention. Invention means new technological advancement, and that is that rights are protected through the patents. For example, we all know that there is so much advancement in terms of communication. We were using a simple phone. Now every phone is advanced, and phones are we are able to do many things from this our mobile phone. So all these technologies, all these advancement is generally protected through the patent, and it's a patent rights. Okay, so and most important thing, these are given for the limited period of time. The basic principle for all the intellectual property is generally the same. That is, two, three principles are generally same. That all the intellectual properties are for the limited period of time. That time period is defined in the law and in the rules, and all the intellectual property should be given for the new thing and some new advancement, not already existing thing. So if a similar technology is already there in public domain or in market, and if an inventor comes and he says that I want to protect this invention as nobody has protected this invention, then such kind of thing will not be acceptable. Even if for design, or even if for trademark, or even if for copyright, the the most important criteria for registering the intellectual property is that it should be having new advancement. In patent, we have to follow that it should be having novel, and it should be having inventive concept. It should be having some modification in or existing technology. So such inventions are protected through the patent rights. So the patent is given by the government of India for limited period of time. But what exactly we take for giving? Why we are giving such a rights? That is very important, and that is that in exchange of full disclosure of his invention. So we give the rights. We give the rights in the one hand, and we take the disclosure of that invention. We take complete exchange of full disclosure of that invention. In full disclosure means what? That how that invention is performed. What is the background of invention? What was the problem in previous invention, and how that problem is solved in this current invention? That all those things you have to mention in that disclosure, and on that basis of disclosure, patent office do their searching that whether it is true that yes, it is novel or new invention, whether that invention filed by the person is having some inventive features. And I will come to the what I mean by inventive features, and whether that invention is capable of having industrial applicability. Means a patent must be given to those kind of invention that will be generated through the industries, not just a theory. It should not be given for the theory. It should be generated through the industrial process. So, so in one hand we take the full disclosure of that invention, and in the other hand we give the rights for limited period of time. The limited period in India is 20 years from the date of filing. If a person filed a patent application today, and if it is eligible for granting, then the rights will be established from will be taken considered term for the patent will be considered from the today up to 20 years from filing date. So what rights we are giving? So as soon as a particular patent is or intellectual property is granted for creator of that intellectual property, he can exclude others from making, using, selling, and importing the patented product or process without the consent of original creator. This is very important. A creator or a person having the intellectual property can exclude others from making. Nobody else can make those patented invention using, selling, importing the patented product or process. Not even we can import the patented products, not even we can sell. Means all kind of commercially exploiting the rights is given to the intellectual property owner or patent owner in this example. So what is the benefit in this patenting process? This is very important to know, everyone, that we take exchange of full disclosure. Why? What is the importance? For example, I can give a very simple example of Thomas Edison. Everybody knows that Thomas Edison has given much efforts, and they have experiment. They do the experiment thousand or more than thousand times to for invention of his bulb or illumination of that particular bulb. But if he wants to protect that rights, that nobody else should make such kind of bulb without my consent, because I have given my efforts and I have given my intellectual for that, and I want to protect that intellectual property. So if he wants to protect that intellectual property, then he have to give the full disclosure to the patent office. Then patent office will go through the full disclosure, whether all the disclosure is correct, whether the information provided by the inventor is correct or not, whether by the disclosure can other person make such kind of bulb just by going through the specification, that all the criteria should be met. If all the criteria, all those criteria are met, then only patent office will issue a patent to that particular inventor. So here the benefit is that, and very important, this disclosure, government of India do not hide from any person. There is some period. After that period, as soon as a particular application, patent application is filed in a patent office, the patent office keep it for 18 months, and after that it publishes on patent office website, and that is open for everyone. Anyone can go through the patent office website, can search for a particular patent, and they can read the specification. And the benefit is what? Like in case of Thomas Edison, all the efforts, as soon as a person knows that this is the way to create a bulb or this is the way to invent a bulb, then he do not needs to do all the those efforts taken by the Thomas Edison. Now he can continue from there. Now he can again modify that original bulb, and they can keep on modifying the bulbs, and they can file a modified patents, and they can protect those kind of advancement of the patent, those kind of advancement in the technology through the patent. So the information is shared among the person. Now this will help in saving the time of other a person having the similar background in the invention or in the field of invention. So other person, other inventor will have the advantage that they can start from the point where the first person has left. But what important thing is that the first person will have the rights for the 20 years. As like Thomas Edison will only have the rights to sell those bulbs or make those bulbs, and he exploit it commercially. But similarly, and on the other hand, he has to disclose the information. That information other person can use for modifying those already invented products. So in this way, the patent will help in encouraging the inventions, and simultaneously it also gives the rights and commercial benefits to the inventor. The next, so the patent is for invention, new technological advancement that gives user benefit and ease of using those things, whatever different kind of technologies. In technologies might be in medicines, technologies might be in communication thing, technologies might be in uh, vehicles, and new different types of vehicles are coming. Today, the age of hybrid vehicles are coming, and electric vehicles are coming. Those all kind of technologies generally are comes through the patenting process, because the efforts taken by the inventor, they want to protect their rights and they want to exclude others from making or using or selling, importing those patented products. So benefit is for them that they only can use or make commercially exploit those patented products, and benefit for others, other inventors. They can easily read, they can understand the invention, they can understand the technology, and they can go ahead from that point of play or that place. So in this way, the patent is granted for the invention. Next intellectual property is the design. Design means only the features of shape. Design means only the features of shape, configuration, pattern or ornament or composition of lines or colors or combination thereof applied to any article, whether two-dimensional or three-dimensional or in both forms. So here we can say that the design is for outer look of a particular product. What particular technology inside that product is irrelevant for a design application. Design application just go for the outer look, and whether it is two-dimensional or three-dimensional, all those features, color features or attractive features that is there in the design, that you have to mention in the design application. This is very important to know that uh, whatever rights we are going to protect, that we have to disclose it properly. So if we are going for the patent applications, then we have to disclose all the information about that patent, about that technology, and what kind of rights do you want from that patent. That all the things you have to mention clearly in the patent application. Similarly, in design application also, you have to mention that which kind of design you are making, which kind of product, for what type of product you making that kind of design. For example, shape of a bottle. There are numerous or thousand types of bottle available in the market, but are they all those bottle are the same? Or if a particular design of a particular bottle may attract a user a lot, and some particular types of design may not be so much attractive for the users. So similarly, in film industry, we know that different kind of clothes are there, and some types are very attractive, and it can give more commercial advantages compared to other products. So these also very important feature. The design is also very important feature to attract the user. So such kind of intellectual property is protected through the design. And again, the term of design in India is for 10 years. Like patent, the term was for 20 years. The term for the patent design is for 10 years, and it can be renewed once for 5 years. So we can say that the term can be up to 15 years for the design application. So what happens when these terms is over? This is very important. Then whenever the term is over, the rights are cancelled, the rights are seized. So anybody can make that design, or anybody can make that patented product by himself or sell that patented product. Now we don't need to take the consent from the original creator. Similarly, in design application, as soon as the term of that design is complete, anybody from any person or any in India, they can make a similar design product, and they can also use for selling and making commercially benefiting, and those intellectual property that comes now, it comes in the public domain. This is the concept, that whenever a term for intellectual property finished or over, that particular intellectual property becomes a public property. It comes in a public domain. So any person can go through the specification of that patented invention, or can go through the design application, and they can use similar design for their product after the expiry of that rights. What if a particular person start making or design or using those patented product or design protected products before the expiry? It is a violation of law, and the violation of law will be done through the all the court procedure, and different penalties can be given to the person. Even a criminal offense can be admitted in violation of any intellectual property uh, when there is some kind of infringement is there, when the term of protection is already there. So we will come to the how to file a design application. For filing a design application, you need to need to fill a form one and one representation sheet. In form one, you have to mention that who is the original creator, what is the name, address, all those things you have to mention, and who is the applicant, whether same inventor is going to be applicant. Applicant is a person who is the having the right. There might be the case that invention is performed in a particular company. The original inventor may be different, but the owners of that invention might be the different. Like a person from inventor from the Samsung company, they are working for the invention, and they have invented some kind of technology, but the rights might be of having of the owner of that company, like Samsung company owner, and such kind of things might be there. So the inventor may be different, and the applicant may be different. So all those things you have to mention in the form one, uh, in the form one of patent application, also in form one of design application. And second most important thing, what is the design? For defining those design, we definitely needs different views of that design. So all those important views by which you can clearly, or any person or office or design office examiners who process go through all those design applications, if it should be clear to him that which kind of design they are protecting and what are the different views, so that all the features are known to the examiner of that particular application. So whenever a patent application or design application or any kind of intellectual property application is filed to the respective offices like patent office, trademark office, copyright office, design office, the examiner or officer who is in charge for that application, they will go through that design application, whether all the things are mentioned correctly or not, whether all the information is disclosed properly or not, like in patent application, whether a person or examiner is clear which kind of invention and what kind of rights they are protecting, and whether these are the new or inventive or not. All those checking will be done, and then only the application will be given the rights or grant. Similarly, in design application, those views you have to give in the specimen of in the representation sheet.
Excuse me, sir. Your mic is
सर
muted.
आपका माइक म्यूट हो गया
Please, sir.
Hello,
Yes, sir.
hello.
Now audible. Yes, sir.
Okay. Whenever my voice, I don't know, automatically it gets muted. Just inform me that it is muted, because I might mean some if somebody start talking, I think it
Okay,
gets
sir.
muted. So let's come
Okay, sir.
to
Okay.
trademark. The trademark, popularly known as a brand name in layman's language, is a visual symbol which may be a word, signature, name, device, label, numerals, or combination of colors used by one undertaking on the goods or services or other articles of commerce to distinguish it from other similar goods or services originating from a different undertaking. So it is very important to know that to differentiate similar goods or services originating from different undertaking, generally they use the trademark or logo to differentiate it. For example, if we can purchase a mobile of a Samsung, or we can purchase mobile from Nokia.
Piyush sir, your mic is again muted.
Hello. Yes.
Yes, sir, now audible.
Okay. So in under modern business condition, a trademark performs four important functions. It identifies the goods or services and its origin. Definitely, for example, if we see two exactly similar looking pen, one pen of Parker company and one pen having no logo or particular uh, trademark applied on that pen, then people can definitely judge and definitely say that this particular pen is from Parker company and it could be manufactured at this place, just by looking the logo, and they can get details of that particular product just by looking the trademark. And second important thing is it guarantees its unchanged quality. Yes, if a similar pen or similar Parker pen is used by some person, the third person can say that yes, this pen my friend has used and it will works in similar fashion, or a similar output will be given by this product also. Just by looking the trademark and type of product, we can guarantee its unchanged quality. It advertise the goods and services. Definitely it helps in the advertisement. If in advertisement, if we see a particular logo or trademark, definitely the promotion will be done for that company. Creates an image for the goods and services. Definitely it creates a goods and image for the goods and services. Again, the like other intellectual property, the term of trademark in India is 10 years initially, and it can be renewed to the lifetime by filing renewal fees in interval of 10 years periodically. So the most important thing, the trademark can be given to the lifetime. The condition is that you have to keep on filing the renewal fees, or you have to renew it after the interval of 10 years. So term of trademark application is can be the lifetime, but it has to be keep on renewing. If you do not renew, then it will again go to the public domain. Any person can use that particular trademark for their business. It might be of same kind of product, uh, that will be no restriction for the if that particular trademark rights are closed. Again, for filing a trademark application, you need to file a TMA form. In TMA form, you have to mention which kind of trademark or logo you are using. The particular logo you have to disclose on the trademark TMA application and all the details of that owner of the trademark, that name and address of the trademark owner. And the most important thing that everyone must know, while filing a trademark application, you have to specify the class. Generally, people who are filing a trademark application, they can do all the work, like they can mention their logo just by looking the form, TMA form. They can fill up the all those details. But what is the class of the trademark? That particular class you have to mention. What do we mean by the class? That in which particular field that trademark logo will be used. For example, that trademark logo will be used in mobile or in communication industry, or it is going to be used in academic industries, or it is going to be used in a particular food industry, or which type of services or goods you are going to use for by, and you are going to apply that trademark, that you have to mention by disclosing the class of trademark. So there are 1 to 45 classes division for these classes, and accordingly you have to search that in which class your trademark application is suited, and you have to mention that particular class in that trademark application. And you have to again mention that since when you are using the trademark, it might be possible that people start using a particular logo for their, as soon as the start of their business, but they do not register initially. They might register after that also, but in that case, you have to mention since when you are using the trademark, and all the details and all the supporting documents you have to give with that trademark application. And description of goods or services, like you have to mention the trademark class 1 to 45, which class, the number you have to mention, and also you need to mention different description of your goods or services. You have to specify that which kind of product, where you are going to use that trademark logo, that you have to mention clearly. Now, let's come to some procedural similarities with all those intellectual property like patent, design, or trademark. Once intellectual property application is filed, after some period of time, it will be open for the public. And like in patent application or in trademark application or in design application, the particular office publishes that this kind of application we have received, and we are going to do the examination procedure on that, whether these trademark are new or can be registered by going through all the act requirement, all the rules requirement, that we just publish it first. We office just generally published it in our website. Now a person who is going to affect by the that particular patent or particular design or a particular trademark, they can come and give the information to the particular office that this trademark application should not be accepted because it will affect my business adversely, or I am the owner of this trademark application. This particular application is copied from my intellectual property. Like those kind of statement they can make, and they can also help the particular office. So such things is always open. After publication, the public have an opportunity to object the trademark registration. Similarly, in design application or similarly in patent application, they can object the registration, that, and they have to mention the different cause of their or reasons of their objections. If they believe they will be damaged by that registration, they then have to mention, and definitely they have to follow the act and rules. Not any reason is acceptable. Some reasons are acceptable that are mentioned in our act and rules. If that reasons are correct, then the officer or the in charge of that particular intellectual property application They will take that matter, and they may uh, refuse the grant of particular intellectual property. So this is similar for all the intellectual property. As soon as uh, a particular application is filed, it is after some time it is open for the public, and anybody can view that. Okay, these are the applications are under process. If that if there is no objection, then definitely that application is accepted by the office, and the rights is given by to the creator or the owner of that particular intellectual property. A different time period is for there. For particular in patent there is a free grant. In trademark also there is a free grant like things. So different time period is already mentioned in the act and rules. Most then next intellectual property is the copyright. Like patent is given for the invention, design is given for the outer look, and the trademark is given for the separating or differentiating the similar goods in the market. The fourth intellectual property is the copyright. Copyright is a right given by the law to creator of literary, dramatic, musical, and artistic works, and producer of cinematograph films and sound recording.
There is some internet issue. Wait for a few minutes, students. Hello, Piyush sir, are you there?
Yes, sir. Priya madam, sir is joining, huh? Students, please stay there.
Okay, madam. Okay, ma'am.
Yes, sir. Now you are audible.
Hello.
Sir. Yeah, yeah, sir. Sir, please on your video also.
Yes, yes, I will do it. Just a minute.
Yes, sir. Yes, sir. Now you are audible and visible also.
Yes, yes, sir.
Sir, your voice is not clear.
Am I audible now?
Yes, sir.
Yes, sir.
Okay. So the copyright is given for the artistic and literary work and musical and now we can see that movies, music, painting, software, internet website, all the intellectual properties are can be protected through the copyright intellectual property. It also provides the its rights the holder rights to restrict unauthorized copying and reproduction of the original expression. Just from the name we can say that copyrights, so nobody can make the copies of that original intellectual thing or original films, or only the owner of that copyright can make or reproduce or copy that particular films or sound recording or works or movies, music, painting, or books or literary work. The without the consent of that original creator, nobody else can make that copies. And by making those copies, the what copyright owner can do, they can use those things to exploit it commercially. They can sell in the market, and they can earn revenue from that particular copyright. But certain conditions are excluded from the copyright. For example, a fair deal of research. If particular person is doing a fair deal of research in that particularly copyrighted thing, that is excluded. Study, criticism, review, and news reporting. For example, might we everybody knows that we see the review of a particular film, and they also disclose some kind of what is the particular theme of that picture and what is the story in brief, and they give their comments. Yes, this film is good, or they give their ratings. All those kind of reporting, reviewing is excluded, as well as the use of work in library and schools. For example, a student might be using particular book, and they can take some drawings and description of for their particular use, or in writing in an exam in a same way. So such kind of literary and school things are excluded from the copyright protection, is and is permitted without specific, and we do not need to take a specific permission from that owner. So except any kind of commercially exploiting those copyright products, we can do the research, or we can do the study on that. We can review our news reporting, as well as we can use for further legislation is permitted. Again, copyright, for filing a copyright, you have to file with a form 14. It is again similar like other forms I have told you in filing a different in intellectual property. In that, in copyright also, you have to give all the disclosure. You have to give all the cinematograph. If you are trying to protect the cinematograph film, you have to give that complete details and complete video of those things, and that will be protected. Again, the duration of copyright is for limited period, but the limited period is larger as compared to the other intellectual property. The limited period, the rights the copyright owner is gives in case of original or all those copyright rights is given is for the lifetime of the author and after the 60 years counted from the death of the author. So it is very important to know that copyright rights are given up to the day after the date of that particular author up to the 60 years. Means if there is some kind of ownership for the Lata Mangeshkar songs, then that copyright ownership is still exist because the death of that particular author or creator is not has not gone beyond the 60 years. So this is very important thing to know that copyright is also for the limited period of time. And most important and general question is that how the website be copyrightable things. Yes, website can be copyright, but you have to give different applications for that particular website. Like in website there might be some photographs, there might be some literature, there might be some musical things, or there might be some appearance, all those different intellectual property you have to register through that different filing different applications for one single website. So always remember, like in patent also, if you are having multiple inventions, 2 or 3 inventions, then you have to file those number of applications. No, you cannot file one application with mentioning all those different invention. You have to file the separate application for separate inventions. Similarly, for design application, you cannot club 4 5 design things, and you cannot file one application. You have to file a different application for different designs. Similarly, for copyright, if there are different types of work, you have to file different applications. And similarly for trademark, if there are multiple trademarks, you have to file with multiple trademark applications with all those requisite fees that is specified in our act and rules. Or everything is specified in our act and rules, and it can be checked through our IP India, Intellectual Property India website. There you can see all the forms, form 1, form 2, or the requisite forms you can download from there. You can fill up those forms, you can edit those form, and you can fill up, and you need to file those particular applications to the particular office. For example, if you want to file a design application, you need to file to the design office that is situated at Kolkata. And you can there are 2 modes of filing. One is online mode of filing. A person can file from any place or through online procedure, or the physical mode of filing. In that particular case, you have to post it only through the speed post to the particular office all those intellectual property documentation, and through that process also the filing can be done. So this is in terms of filing. So I will check. I will give a one simple example to understand what is different intellectual property. For example, a mobile phone. Every person is having a mobile phone in a nowadays. So what are intellectual property involved in particular mobile phone? Let us discuss here in a brief. So whenever we purchase a phone, we find a logo or particular logo of on that phone, that who is the creator of that particular mobile phone. Like if it is made by the Samsung, somewhere Samsung logo will be there, or it is made by the Google, then Google logo will be there. So this is the trademark intellectual property that is used here. So and second, different designs of phones are available. The shapes of phones are available. Some phones are very slim, some phones having different buttons positions. All these outer look is protected through the design intellectual property. Then what are the softwares inside these phones, or what is the information available with these phones? The manual of that phone and all those things are protected through the copyright intellectual property, and all those different new features like advancement in video or video mode or cameras or connectivity features, Bluetooth, Wi-Fi, and the screen touch. All those technical features are protected through the patent intellectual property. So in one product, there might be the case that multiple intellectual property may involve to uh, sell that product in a market properly. So in this way, the intellectual property is a very important tool. And what are the advantages of this intellectual property? The advantage is definitely it avoids duplication of research. Yes, I already gave you the one simple example of Thomas Edison, that it avoids the duplication of research. The third person or person having similar knowledge or working in a similar field, he do not need to do all those research. He can just carry forward from that point of research that other patented owner has disclosed. The second most important advantage is it utilize the published patent specification is a ocean of knowledge. Even a design application is a ocean of knowledge. Any person can go through design application. They can view different designs, and they can judge that how these designs are different attractive designs are made in for successfully commercially exploiting particular thing. So this definitely these all the intellectual property is a ocean of knowledge, and transferring invention as a public property after expiry of the term is also very important phenomenon or important advantage of the intellectual property. For example, let's talk the example of the medicine. We all generally knows that medicine people do the various kind of detailed research and hard work to invent a particular medicine for a particular disease. So for the first 20 years, they are going to get monopoly rights. But after that, that particular intellectual property becomes a public property, and anybody can make those particular medicine and sell in the market. So a private property gets transferred to the public property, and it is again become more helpful to the people. Initially was also the helpful, but the more helpful thing is achieved through this transferring as a public property after expiry of the term or cessation of the patent. As soon as the copyright term is finished, anybody can make, use, sell, or copy that particular copyright product. So in this way, this is also very important, and providing rewards as a exclusive rights for disclosure, and we are giving the rewards to the original creator. That is also, and we give the motivation for the researcher, and in this way the more and more research and more intellectual property comes into the market, and this is also very helpful for the nation building and growing a GDP of our nation. So these are the some brief things I have given you about the intellectual property. If any doubt is there for a particular slide or a particular term which I have disclosed, you can please go ahead and ask me for. Yes, over
Thank you
to.
so much, Piyush sir.
Yes.
I would say you gave justice to the subject of the webinar, that is IPR awareness. I literally say, after listening this webinar, all the queries of students have been cleared regarding the terms, regarding the procedures, regarding their definition, or regarding the office situations and whatever, wherever they were situated, everything, each and everything you have tried to cover up here. Now, I would like to request my students, those students are having queries, they can raise your hand so that we can take your question answer session, and sir will guide you properly. So students, आप raise कर सकते हैं hand, those who are having questions. I would like to request Rahul sir to allow students mic. Give me a second, sir. We are trying to
Yes,
unmute
yes.
student. Okay, now students, you can unmute yourself. Those who are having queries, they can ask. Okay, one question came here. Okay, in terms of cinematograph film, who will have the copyright?
Definitely, the producer of that cinematograph film is going to have that ownership, and ownership is not very particular or very fixed term. It can be given to any person just by mutual agreement. For example, in patent also there can be transfer of rights to the multiple ownership. Can we can see, and all those can be done through the agreement. If there might be chance that owner might be some or creator might be some other person, and he might give the ownership to other person, they may take the royalty for that or they may not take the royalty for that. That is immaterial for us. That is everything will be mentioned in the agreement. According to agreement only, all the ownership will be processed, and they have to also mention to the particular office also that ownership is changed. For example, in patent application, if transfer of right is done, then they have to also inform the patent office that yes, transfer of right is done, and we also register those kind of changes in our database, and that database is open for everyone.
Thank you, sir. Any other questions, students? Okay, definitely in future also, sir, our students, if
Yes,
they got any problem, we are seeking your help, and
definitely.
definitely you will be there to guide us.
Yes,
Okay, sir.
yes.
And this is not the end point. We want such kind of information from you in future also. In next session
Okay.
also, we will invite you for further more information regarding intellectual property rights, sir. Now, I would like
Yes.
to give vote of thanks. I would take this opportunity to take vote of thanks for this program. Good afternoon, everyone. It's such an honor to be a part of this wonderful been asked to offer a vote of thanks on this occasion of today's webinar. On behalf of Dayanand Law College, I would like to extend my gratitude to our esteemed guest, Piyush Lende sir, for sharing their graceful words. Their thoughts will be always with us. My sincere thanks to our in-charge principal madam, Dr. Poonam Nathani madam, for giving permission to arrange this program. Also, I would like to thank Dr. G. Lakshman sir for organizing such a fruitful seminar. I would like to thank our technical support, Mr. Rahul Chauhan, for his technical support. Lastly, a wide round of flowers for all our students for attending this seminar gracefully and listening carefully. So hope your doubts are clear now, and thank you, Piyush sir, for your
Thank you.
supportive and informative webinar. And here the seminar is concluded here. Thank you, sir.
Thank you.
Thank you so much, sir.
With the permission of
Students
principal
are
madam.
requested, yes, madam, students are requested to please fill up the feedback form. It will be circulated at WhatsApp group. so that they can get e-certificate.
Yes,
Thank you,
yes,
madam.
madam. Yes, thank you, ma'am. Students, before leaving, take this notice. If you the students who will fill the feedback form, which will be provided on your WhatsApp group, they will get certificate of this webinar. And thank you everyone for attending very gracefully. Now here, this seminar is concluded. Thank you everyone.